A Florida mom is under arrest, accused of causing the death of her 9-month-old baby boy. And you will not believe what the medical examiner found in the little boy's stomach, which led to a charge of second-degree murder. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Real quick, you know one of the reasons why we can cover a story like this? It's because of our sponsor, Morgan & Morgan. I'm talking America's largest personal injury law firm. I'm talking a firm with over 1,000 attorneys who've recovered $25 billion for more than 500,000 clients. In fact, in the past few months alone, a client in Florida received $12 million when insurance offered just $350,000. Out in Pennsylvania, another client was awarded $26 million. That is 40 times the insurer's offer. And Morgan & Morgan, they make it easy to fight for what you deserve. You can even start a claim from your phone. So if you're injured, you can start a claim at forthepeople.com/LC Sidebar. You can click the link below, or you can scan the QR code on screen. A woman in Miami, Florida lost a child last year. And unsurprisingly, that prompted sympathy and condolences from her loved ones and the community. But police say they allege that little Sebastian's death was preventable, and that it was his own mother's fault that he's gone. July 2nd, 2024, according to Miami-Dade County investigators, Sebastian was rushed to a hospital from the family's apartment where he was pronounced dead in the emergency room. And as Sebastian's tiny body was prepared for an autopsy, Miami-Dade County Sheriff's deputies and homicide detectives, they opened an investigation. And this little boy's mother, Natalia Munoz-Paulino, was devastated at first, right? She posted memorial photos of the 9-month-old on social media, mourning his loss. But on Monday, November 10th, 26-year-old Munoz-Paulino was arrested for his murder. According to an arrest report that was reviewed by local news outlet WPLG, Sebastian died from, get this, lethal levels of methamphetamine and cocaine. To talk about this, what could come from this, what we should expect, I want to welcome on criminal defense attorney Kaysia Earley. Kaysia, thanks so much for taking the time. Here's the thing that's interesting. The medical examiner apparently determined that the drugs were physically ingested by this boy, by Sebastian, rather than being transferred to him through breastfeeding. Why is that important from a legal context?
Because it goes to the negligence, the aggravated abuse charges that's coupled with the second-degree murder charges. It shows that she was negligent in keeping these drugs out in the open. Now, it's her testimony that she was cradling this 9-month-old angel, and to her surprise, when she woke up, he was unresponsive, purple, and that's when she called authorities. But then her story changes. She tells one person something else. She tells the police something else. So it shows that her intent level was there because she's covering up what she knows to be true. And also, if this was ingested through breast milk, could have been, it goes to intent. Did she intentionally try to, harm the baby, knowing that she was taking drugs and breastfeeding at the same time? But the level of neglect, the level of abuse is actually leaving the meth, the cocaine out in the open so that this beautiful angel, 9-month-old Sebastian, can ingest these harmful chemicals.
You talked about it a little bit. When we're talking second-degree murder here, what is the theory of the case, right? It's not necessarily an intent to kill, or is there, or is it there's a substantial risk that's known, and it's there's a disregard for that, because I think that's an important distinction here, right? So she was charged with second-degree murder / aggravated child abuse. What are we talking about there in terms of the charge?
It's the difference between, like you said, the reckless disregard, the depraved mind, and the level of intent. So the second-degree murder coupled with the aggravated abuse of a child in this case goes to the intent and the motive of during that time. So again, we know that the facts of this case is she claims that she was asleep, but the issue goes to whether or not there was some aggravating factors. In this case, we know that there were drugs that this baby allegedly ingested that caused this baby to go into this lethal overdose and ultimately die. So it goes to the depravity as well as the intent.
A lot more I want to get into, but I just also want a clarity on the timeline here, because Sebastian died on July 2nd, 2024. His autopsy was performed 2 days later, but according to reporting from WPLG, the medical examiner didn't rule his manner of death as homicide until May of this year, and she wasn't arrested until Monday. Why that timeline?
It always depends on various factors because sometimes you can have the autopsy, then the baby is buried, and then later on through the investigation, because the investigation was still ongoing, they had to make a determination as to, based on the conditions of the home, and to clarify whether or not it was ingested through her breast milk or whether there was a possibility that these drugs were out. So there could have been the delay in the ongoing investigation, but the delay in ruling it as a homicide does not mean that the state does not have sufficient evidence to move forward with that homicide. And you have to think that these forensic pathologists, they have other cases. So sometimes it goes, they're being processed in the order that's being received. So a host of factors can make that determination as to why there was a delay in the ultimate ruling of a homicide.
Let me go into this a little bit more. So first of all, we should know that at 9 months old, according to the American Academy of Pediatrics, most babies, they're starting to sit up on their own, roll back and forth from their stomach to their back, and hold things in their hands. And as we know, once babies have something in their hands, they're very likely to put it in their mouths. And that is what police say likely happened to, again, 9-month-old Sebastian. He somehow got his hands on these dangerous drugs inside what should have been a safe and caring environment. According to documents that were reviewed by WPLG, investigators went to the family's apartment where they basically found a gigantic mess. The apartment was described as being disheveled, unkempt, there was trash, there was spoiled food, there was clothing, there was used hygiene products all over the floor. It's disgusting. The arrest report reads, quote, "The environment was unconducive for children to live in as several items which could be harmful to a child's health and well-being were scattered on the floor." And the arrest report also notes that there were items within reach of children that would be dangerous. In fact, deputies indicated that at one point they had to physically intervene because another child in the home was drinking baby oil from a bottle. And the defendant here, Munoz-Paulino, wasn't allegedly doing anything to stop it. So that's right, Sebastian wasn't Munoz-Paulino's only child. According to her Facebook page, she had an older son as well. The arrest report says that Sebastian's father, he worked out of state. So if you were wondering what the connection is here, but Kaysia, let's start there. What happens to the other child? Does this other child stay with the father? Does it depend on the condition of the home? What happens when you're dealing with multiple children and other children in a home?
Well, first you have this disaster, right? You have mom on drugs. You have her allowing her children to live in deplorable conditions. So this is a recipe of just safety and welfare. And in this case, usually the Department of Children and Family will do a welfare check. They will create a report, and they need to find out what is in the best interest of the child. We know that dad works out of state. So even though he's a biological father, he would technically be the next in line. Does he have the capacity to care for the remaining child? And they will do a detailed check. And sometimes that child will be in place of the state until a reasonable lodging is available, whether it's extended family members. But just as you stated, this whole case is heartbreaking because you had law enforcement on scene, and mom wasn't even in the right state of mind to stop her other child from ingesting baby oil. And we also know that the autopsy report revealed that 9-month-old Sebastian not only had eggshells in his stomach, but he also had feathers. What else did he have? 9-month-old, you're not even walking at this point. So that means either mom was not paying attention to this baby. And as you stated, anything they put in their hand, anything that they can grasp, they normally a natural reaction is to put it in your mouth. So we don't know what else he was capable of digestion prior to this autopsy, but we know one thing for sure, and this is what the prosecution is going to have to paint for the jury, that this baby, even if the baby was crawling, the baby had to get within arm's reach of the meth, the cocaine, in order to pick it up and place it in his mouth. And what mom is trying to do is trying to stare that evidence away by saying, well, I did take drugs, but it was a week prior, or I don't know how he got that because I wasn't breastfeeding. The only logical explanation is you took these drugs, you were knocked out, and you left it out within reach. And thankfully, the other child that she had did not have access to that, but unfortunately, we know baby Sebastian did.
And to be clear about something, a parent's not going to be arrested for having a dirty home, right? That's not, but this is a component, this is part of the pattern, this is part of the evidence that prosecutors will use here. And you mentioned it. So the arrest report says that when the Miami-Dade Medical Examiner's Office performed this autopsy on Sebastian, they found eggshells and feathers inside of his stomach. And a toxicology report revealed that there were fatal levels of both cocaine and meth. And Munoz-Paulino allegedly admitted to using drugs the weekend before Sebastian died while hosting a party. This is according to NBC Miami. Couldn't give police many details there. But the point about this is, Kaysia, right? Would she have been charged if it's one incident? Or are they trying to say this was happening over a period of time? That's the way they're going to tell the story, right? It wasn't just an accident where a child got a hold of something. If this is a condition that's built up for quite some time, these deplorable conditions were built up for quite some time, that seems to be what they're trying to suggest here, right?
But they necessarily don't have to even prove this whole buildup. It's the fact that there were deplorable conditions, nasty infestation, cluttered home, and you can be charged with that neglect because it's providing a safe environment for your child. And if you have all of these items, you're not keeping a clean home, it can make the child susceptible to any other diseases or infections based on your sanitary level. So even if the prosecution goes at an angle where, yes, this was ongoing, they can also say that she was neglected the child simply by having the drugs present within arm reach. That in of itself it's not safe for the child. Yeah, you're using drugs, but the question becomes, why did you have it out for a child that wasn't able to walk around? It had to be right there when she fell asleep.
I just want to ask you real quick about the father. So the boy's father reportedly told investigators that Munoz-Paulino had previously admitted to him that she used those drugs. He also reportedly claims that he once saw drugs inside of the apartment. From a legal point of view, would he be criminally or civilly responsible in any way if he knew the children were in a dangerous situation but didn't do anything to help them? I mean, theoretically speaking here.
Absolutely. As the father, there's charges of failure to act to prevent child abuse. There are certain charges, but there has to be sufficient evidence that he failed to act. If he had prior knowledge that not only was she using drugs, but she also kept them out and was prone to pass out after taking drugs, then yes, he could be responsible based on that admission. But just having a spouse or having a parent of your child being on drugs or abusing drugs, that in and of itself is not sufficient to charge the other parent with child neglect or child abuse. But knowing that they had a habit of keeping the drugs out, passing out, or placing the children in an unsafe environment, he can be charged as well. But there's other factors to consider. Did they live together? Did he know the conditions of the home? Was he aware of her drug habits and keeping the drugs out? And also, is he in the position to care for the child? So there's a lot of factors that the prosecution would have to consider before making that determination, whether filing charges are appropriate for the father.
Yeah, I was curious about that, and I'm not saying that he's charged or going to be charged. I want to be clear about that. But going back to her, Munoz-Paulino, as we mentioned, charged with second-degree murder, aggravated child abuse. I'm struggling to figure out what the defense is going to be here, because we talk about this all the time when you're dealing with such a young victim, a vulnerable victim, and they're in a certain state, you have to always essentially blame the caregiver, right? If a child is sick or a child is ingesting materials or a child has bruises, it's not like an adult where there could be other rational explanations for what happened. Does she call a medical examiner to say this is not what was in the body, that this was not what caused complications? Does she put the blame on somebody else and say, I had no idea what was going on? Again, I'm struggling here for what a defense could be. Or is it, hey, can we negate this down? That maybe it's not second-degree murder, but it's a lesser charge. What could a defense be here?
Well, in cases like this, especially when the evidence is overwhelming, usually I have a conversation with my clients and I tell them there's really two avenues we can take. We can go down one road, which is mitigation. Let's get you evaluated. Let the prosecution see that you had a history of drug use. You never had treatment. There may be some mental illnesses that need to be addressed that you never had addressed. Let's get you evaluated. Let's get that mitigation report, incorporate the evaluation from the doctor, and let's see if we can plead this out to a better deal. Or if the defendant is gung-ho and does not want to take a deal, then you try to present those mitigating factors during trial and hope for a lesser included. In this case, you have the second-degree murder, but you also have the aggravated child abuse case. So it always depends. But here's the problem. In Florida, you cannot claim as a defense or justification voluntary drug use that you were not in the right state of mind. Now, if someone, let's say, spiked her drink or, she took the drugs unknowingly, that would be a great defense that she was not in the right state of mind. That was not her drugs. If someone else was over there and she had no idea. But we don't have that in its case. That was her own personal use. No one else was in the home. So she really doesn't have a defense. So just because you have the right to counsel, you have the right to go to trial, you do not have a right to a not guilty verdict. So in this case, she really needs to analyze the evidence. Yes, you're innocent until proven guilty, but sometimes the facts are against you and they're overwhelming. So I would suggest that she mitigate this case, because if she's found guilty in Florida, being convicted of a second-degree murder, the maximum punishment is life in prison.
Talk about evidence. You talk about bad evidence. There's something I haven't even mentioned yet, something that certainly does not help Munoz-Paulino. And that is that she allegedly changed her story several times when it came to what happened to Sebastian. So according to WPLG's review of the arrest report, at first she reportedly claimed that he fell asleep while she was holding him, and when she woke up, he was unresponsive. Now, deputies said that she later claimed that actually he'd fallen and hit his head, but she allegedly told child welfare workers that he drowned in the bathtub and told the boy's father that he choked on something. Now, Kaysia, from a defense perspective, could you say this is a mother who's panicking? She didn't know what she was saying. She's not deliberately misleading anybody. Or, if this can be proven by prosecutors, it looks like somebody trying to cover their tracks. It's what we call in the law consciousness of guilt. How bad is this?
It's bad. And even if she testifies, she's going to be impeached. She gave multiple inconsistent statements. And as a mother, this is not someone panicking, because mothers are nurturers. Mothers want to find out what happened to their child, especially in a situation as this. So we're not going to tell multiple stories. The truth is always consistent. So the problem that she's going to have if she chooses to take this to trial is that she lacks credibility. And usually when there aren't any witnesses and the jury does not believe you, it's typically a guilty verdict, because what else are they supposed to believe if the mother has given multiple inconsistent statements? She's trying to separate herself from the drugs that we know were present in the baby's stomach. So it's unfortunate, but this is not a good case to take the trial, simply because we know that she was solely responsible for the death of her son, and lying and giving multiple stories doesn't make her case any better.
By the way, the medical examiner's office was apparently able to rule out suffocation or airway obstruction during the autopsy. This is according to WPLG. How critical is that when we're talking about this case?
It's very critical, because what you don't want to leave as a prosecution is room for reasonable doubt. The prosecution's burden is to prove each and every element of the crime beyond a reasonable doubt. And if there's some doubt that, wait a minute, maybe although there's a lethal dose of meth and cocaine, could it have been possible that this baby had a pattern of putting items in his mouth and he technically didn't die first of this lethal dose? He probably choked first and wasn't able to breathe. So you're ruling out all of these possibilities, because once the jury goes back there and they deliberate, you have different theories based on the evidence presented. So you want to make sure as a prosecution that you do not have that doubt in the jury, because that one person can leave a hung jury. So it's very important that the prosecution, through their forensic experts, rule out there was possible suffocation or any other post-head trauma, right, or drowning.
Yeah, and that's maybe where you'd have a defense medical examiner try to dispute that. But anyway, put that to the side. Something I want to play. So Munoz-Paulino appeared for a bond hearing on Tuesday, and a Spanish interpreter helped make sure that she understood what was going on in court. And she looked distraught when she seemingly realized that she was going to be spending another night in jail. Take a look.
No bond.
No bond.
No califica para fianza, ¿no? Report for your final hearing tomorrow.
Debe comparecer o comparecerá en relación a su audiencia final en relación a esto mañana.
Now, the judge scheduled Munoz-Paulino for a pretrial detention hearing today, when a judge can decide whether she should be released pending trial. By the time of this recording, we don't know what that decision will be. But Kaysia, would you expect her to get pretrial release?
Absolutely not. In the state of Florida, I've tried many murder trials or second degree, and typically you don't get a bond. I don't know if this pretrial hearing is going to be an author hearing, which has two prongs. You have to prove a proof evident presumption, great, the state. And then even if proof evident and presumption is great that this crime was committed and she's a person that committed the crime, the judge then has to determine whether or not there's reasonable conditions and balance that with the safety of the community. And there's various factors that the judge has to consider. And in this case, she was harmful not only to baby Sebastian, 9-month-old, but also to her other child. So I do not believe, based on the evidence, based on the facts and circumstances of this case, that she will be granted a bond. Typically, cases like this, murder cases, it is a danger to the community. Oftentimes people think, oh, it's just drugs, it's not a gun, it's not a violent crime. But look what happened in this circumstance. This is why drugs are dangerous and ultimately lethal in innocent people. So I don't believe the judge will grant a bond in this case.
Oh, and one other thing I didn't mention as well, okay? This isn't Munoz-Paulino's only legal problem right now. No, according to Miami-Dade court records, she was arrested in 2021 and charged with possession of a controlled substance as well as possession of drug paraphernalia. The state ended up not prosecuting her for the drugs. Instead, she was adjudicated guilty in 2023 on the misdemeanor paraphernalia charge. She was ordered to pay a little over $300 in fines and court costs, but according to the records, she didn't pay. And the case was sent to collections. It also appears that she was arrested for battery in 2023, but that case was dropped. The question I have now is if she has, Kaysia, these prior charges, these prior drug charges on her record, how badly does that hurt her case? Does it come up at a trial? I guess it would come up at a trial if she were to testify, right? But talk to me how it might affect it.
It certainly wouldn't come up during trial because some of the cases were null pros or dismissed. Right. But sometimes the judge, once the case is dismissed, it's not weighed heavily in the judge determining whether or not the defendant should get a bond. But there's definitely the judge looks at the criminal history, safety to the community, ties to the community, whether or not she will make herself available to court. Because again, the purpose of pretrial release is not simply as punishment, because that would be a violation against the Eighth Amendment. Cruel and unusual punishment is to ensure the safety of the community and make sure that you will be at your next trial date. But based on the circumstances of this case, and even with her taking that misdemeanor adjudication, I don't believe that the judge will release her.
Now, the court docket shows that Munoz-Paulino has been assigned a public defender who waived arraignment, entered a written not guilty plea on her behalf. Just a tragic situation. Kaysia Earley, thank you so much for taking the time. Really appreciate it.
Thanks for having me, Jesse.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.